he really likes to try to sit down with people and say, well, what do I need to give you? What is it that will make you happy and make you go away? And my concern when I was talking to one of the landowners was, as good as the issues that he was bringing up that they were in discussion over, my fear was that some of you, particularly who are in that situation, it's like the Titanic. You're only seeing the 10% of the iceberg that is above the water, but if you have not actually read any of these 40,000 pages, you have not seen the 90% that's underneath the water that will put you out of business even if you do negotiate the stuff on that other 10%. So hopefully, I will go through some of that and it will become a little bit clearer. So I guess I would caution all of you that are in that situation, maybe just be careful about negotiating too early, and at least from a thinking that it's a settled standpoint, because again, as these documents progress and go on, we will learn more about them and maybe want to have other things addressed. I even think today at this point, I really have not obviously read all the pages myself either, or all the chapters. But I thought, timing-wise, this is a good place to start, to at least share with you what I have seen so far. I suspect that the administration is on track. They want to release their public document October 1st. So my thought is we could have one other informational hearing, that at the next one I could share the other impacts that I read between then and now. And I think we need to have a third one, because I really would like to go over what the mitigations are that they are providing in the plan, just so you can have an understanding of how inadequate they are, and that they're really limited by words like if feasible, if affordable, if the locals sign an agreement with us, then we'll do these things. Those are not hard and fast, will make you whole mitigations by any stretch. But again, I probably am going to hit on maybe 2 of those today, I think. But that in and of itself, I think, will warrant a whole meeting, just so you can understand what they're offering you in exchange. So then one of the last things here is, again, we are on a time constraint. I'm going to try and go through a lot. So as much as I like questions, and I do want to hear from you eventually of, again, examples of, hey, did you think about this, Melinda? The other big thing that I noticed when reading these documents was there's a lot of omissions. There are things that they didn't even analyze, that they don't even know is an issue or a problem, that are quite significant. I've tried to tell them in some of our meetings, because of that, and because of how they've really not mitigated anything and not really analyzed anything to a level that is considered project level, that despite what they think and what they say, conservation measure 1, which is the conveyance facilities, is not really analyzed to project level. It's more programmatic. Their conservation measures 2 through 22, they admit and purposely have called them programmatic, that they will have environmental reviews done later, but their expectation is they're project ready for the conveyance facilities. But again, I'm not an attorney like Scott, but I even think it's obvious to me, with my limited knowledge on CEQA anyway, which is the state environmental law, I'm not as familiar with NEPA, that they haven't even come close to meeting those standards. And I think towards the end I'll talk about the fish, and you'll see that not only that, they really haven't come close to meeting their standards on a habitat conservation plan or a national natural communities conservation plan. The HCP, the habitat plan, is a federal document plan. The NCCP is the state version, and they're both related to the Endangered Species Act, the federal and the state Endangered Species Act. And they have really good purposes, which is, rather than trying to deal with individual species one at a time, that if you do a habitat plan, a habitat conservation plan, you try to do them all so that whatever your activity is, you can keep going and you don't get, the death by 1,000 pets for each species. Conceptually, it's great. And that's what the BDCP is. It's a combination of trying to get permitted for those 2 things. But ESA laws are like here. So under the law, you're all farmers. I'm sure you've experienced this somewhere along the way. that you're regulated here by both the state and federal laws, and they say you can't do this or you have to do that based on these laws, okay? If you're doing an HCP or NCCP, you agree in that document and that plan that you're going to do more. You're going to do more than what those laws require you to do in order to not just avoid harm or killing or creating jeopardy for those species, but that extra amount that you're going to do above not harming them is going to contribute to some level of recovery for those species. Okay, and like I said, so I'll get towards the end and you'll see even on the fishery stuff that they aren't even getting close to really improving the fish, and in fact, for some, they're going to make it worse, which then I don't care who you are or where you are in the state, but particularly north of us and here, because of the salmon, if you're making them worse, now it increases the regulatory burdens on them if those populations are actually getting worse because of the project, not better. Okay.